Okay, hello everybody. Jeff Wyron with Remax Equity Group. On behalf of Oregon Real Estate Forums, we're going to get started here in about a minute. So grab a cup of coffee, grab a cup of water, and make yourselves comfortable. We've got a good webinar today, and should be about 90 minutes long. So we'll get started here in just a brief moment. Okay, we're going to go ahead and get started. So welcome everybody to the webinar today on acceptance and the general rules of acceptance. And I think we're going to have a great discussion today and a good opportunity for you to ask some questions. The commitment that I'll always make is that if you ask us a question, we're going to do our best to answer it. So even if you ask a question and we don't answer it during the webinar, we'll do our best to get you an answer after the webinar is complete. So bear with us. We'll do our best to get to all of your questions. But the other thing that I would say is on occasion we don't answer a question that we've already answered. So if you don't get a response from us, you may look through the history and see that your answer has already been given. Okay, so we're going to go ahead and get started. I'm going to pull up the handout that we're going to be looking at for today. I'll give you a quick outline as to what we're talking about. So can we verify that they can hear me?
Lance says he can't hear. That you cannot hear anything.
Should we undial and dial back in? Hit that button and see if we're on. Okay, verifying audio connection.
You still can't hear?
Okay. Well, we're going to roll with it. So we'll get notice, I'm sure, if people can't hear us. But according to what's on my screen, we're on board and people can hear me. So we're going to go for it. So what we're going to do today is talk about a discussion about contract law and acceptance of an agreement from a legal perspective. We'll review the history of acceptance in the OREF sale agreement. Obviously, there were some changes that were made for the 2015 forms release, and we'll talk about an explanation of those changes. And then we'll have a discussion about the implication of acceptance on a transaction. We have a few examples to go over. And then we'll have time for Q&A at the end, and I'll moderate that. So plenty of time to get to all of your questions. I'm going to turn it over to Phil Queren. Phil Queren is the legal counsel for the Oregon Real Estate Forums Committee. And so without further ado, Phil, I'm going to turn it over to you.
Good afternoon, everyone. Jeff said I was going to talk about the history of offer and acceptance and so on in the sale agreement, and I think that's a good place to start. Until this 2015 sale agreement, we didn't have anything definitive in the sale agreement itself as to when the contract became binding. I think a lot of people sensed when it was, and certainly contract law said when it was, but what we thought was that in the definitions and instructions section of the sale agreement, we would be a little more specific. And so what we did is we said, and this is in section, I believe it's section 4, section 1 of the definitions and instructions, says, unless seller and buyer expressly provide otherwise, the phrase, quote, signed and accepted, end quote, in the printed text of this sale agreement or any addendum or counteroffer, however designated, shall mean the date and time that either the seller and or the buyer have A, signed their acceptance of the agreement received from the other party or their licensee, and that's important, and transmitted it to the sending party or their licensee either manually, by facsimile, or electronic mail. So what that means is that for all intents and purposes, if you see the terms signed and accepted as a part of the instructions of in the sale agreement or an offer, a counteroffer, or even in an addendum, what that means is that it's got to be signed, and then that signed document has to be transmitted to the other side. So that doesn't change contract law. Contract law has always been that. It's just that we are specifically saying it. So in order to put a finer point on that, what we're going to be doing is spending a fair amount of time going forward talking about how these laws work. But before we do, I have prepared a list of what I call general rules of contract formation. And essentially what they are is rules that you want to really, you want them to be second nature to you. And number one, notice to the agent is notice to the principal. So for all intents and purposes, you should regard any notice that you receive as an agent as notice to your principal. And what that really means is that it's incumbent on you to make sure that you immediately transmit any information such as an acceptance or an offer to your client, because the clock has already started ticking as of the time that you received it. So notice to you is notice to your principal, whether it's a seller or the buyer. Second point, an offer conveys to the other party, the offeree, the one to whom you are making the offer, the, quote, power of acceptance for so long as the offer remains open. For so long as the offer remains open. So as you know, in the sale agreement itself, where the offer is being made and signed by the seller, or excuse me, signed by the buyer, there is a period of time for you to put in how long the offer will remain open. I'm looking at my sale agreement. I'm looking at line 457. I don't know if you have the same line, page 10 of 11, but it says this offer shall automatically expire on, and then you insert the date and the time. That's the offer deadline. If not accepted by that time, the buyer, if not accepted by that time. So the deadline has got to be accepted by the offer deadline. Buyer may withdraw this offer before the offer deadline at any time prior to seller's acceptance. So again, what that means is that as long as the offer has not been, quote, signed and accepted, then the buyer can withdraw or revoke that offer. Once the offer has been signed and accepted, which has been transmitted, that signed document has to be transmitted to the other side, then the buyer's ability to revoke that transaction goes away. Number three, contract becomes binding when there is mutual agreement, i.e. a meeting of the minds. And that is basic contract law 101. That is to say, the offer has to be accepted on the same terms as the offer was made. So if the offeree, the seller, for example, to whom the offer is made, attempts to vary the terms of that offer, then it is not an acceptance on those same terms. There is no meeting of the minds, and at best, when a seller signs an offer but attempts to change certain provisions in that offer, they're really making a counteroffer. They cannot accept the offer by making changes to it and then accepting it. A meeting of the minds occurs when you have acceptance on the same terms as the offer. So if there are different terms, then the offer has been changed, the acceptance has been changed into a counteroffer. What is a counteroffer? It's two things. A counteroffer is two things. Number one, it's a rejection of the offer. And number two, it's a new offer. It's a rejection and a new offer. And we'll be talking about that in more detail later. If an offer is revoked by the person making it, that'd be the offeror is making the offer. If it's revoked or withdrawn prior to acceptance, then it takes away the offeree's power of acceptance. So if the buyer makes an offer and says, I'll buy the property for $500,000, cash on the barrel, no financing, the buyer is making that offer. It's got to be accepted, say, by 5 p.m. the end of the day. And if before the seller signs and accepts, i.e. signs the offer, accepting it, and then transmitting it, the buyer can change their mind, and they would then have to communicate their revocation to the seller. And that way they have taken away from the seller the power of acceptance.
If I can interrupt you real quick, Phil, we have a question about the point of the counteroffer being not only a counter on new terms, but a rejection of the original offer. And the question is, since it's a rejection, why do we only change those items that we don't agree to on the counteroffer?
Well, a rejection comes in many different ways. I mean, any change of the offer is a rejection of the offer. Now, and then it's a new offer. So when the seller says, I'll accept X, Y, and Z, but I'm gonna add A, B, and C, that is the new offer. Now, that's not the same as saying that the rejection of the offer doesn't exist. It is. The offer is being rejected, and the counter offer is incorporating the unobjectionable portions of the offer. So it's re-upping those, and then it's adding new terms.
And it states that on the counteroffer documents.
Yes. That
this counteroffer, the language states that all of the terms of the offer, other than what's modified below, are agreed to.
Well, that's a good point, because I think a lot of times people forget that. You only want to put into the counteroffer those new provisions of your counteroffer. Anything that is not rejected by a new provision then remains the same. And that's, as Jeff said, that's what it calls for. So make sure, if you only want to make one change in say, the price, then everything else has been accepted. The only thing that's different is the price, and that's the terms then of the counteroffer. But remember, there is no offer on the table anymore. There is only a counteroffer on the table, because the offer was rejected implicitly by the terms of the counteroffer. So a counteroffer does two things. It rejects the offer, and it makes a new offer.
Good point. I think a lot of people don't necessarily readily assume that or understand that, so I think that's a very, very good point.
Number 8, the same rule applies for acceptance of counteroffers. Okay, so to be clear, so if you're going to have a counteroffer, like I said, a counteroffer is not only a rejection, but just a new offer. So a new offer can be withdrawn at any time prior to the offeree's transmission of acceptance. So you look at it exactly the same. It's a new offer, and it's capable of being accepted if done so within the time frame given on the counteroffer. And if it's not accepted before a revocation of the counteroffer comes in, then the revocation is going to be effective. Okay. I think I've already commented on this about what the counteroffer does, so I'm going to move on. We're going to talk about some examples now.
Before we get into the examples, and maybe you mentioned it in your discussion while I was trying to sort out the audio with Monica, but can you talk a little bit about the changes that we made to the 2015 agreement and, I think an important point is, what we did in the 2015 forms release is include language about signed and accepted in transmission that is consistent with what contract law actually is. We haven't changed contract law. I mean, it is what it is and has been. We've just incorporated language to the effect into the sale agreement so that the buyer and seller are clear about when you have a binding contract. Is that fair to say?
Yes, that's correct. I did cover Section 4, subsection 4 of Section 1 definitions and instructions to say that when the offer or counteroffer, whichever, has been signed by the other party and it's been transmitted, i.e. it's been dropped in the mail, it's been manually delivered, it's been faxed, all of those events, any of those events will constitute transmission. So as long as you're transmitting the signed document, then you have a binding agreement at that time. Let me go back a few generations. Back in the days before there was electronic transmission, there was the U.S. mail. And so when offers were transmitted through the mail, if an offer went from a buyer to a seller through the mail, then how would you determine when the seller had, quote, signed and accepted? Same concept. It's when he or she signed and transmitted that signed document. So what is transmission? The answer is and was and continues to be when they drop it in the mailbox. That is the date of transmission or the date and time. The reason for this whole concept of transmission is that it's the point at which, at least is sort of a legal fiction, the point at which the acceptance becomes irretrievable in theory. I mean, you can't reach down the mailbox to grab it. So that was called the mailbox rule or the dispatch rule. When the acceptance was mailed, dropped in the mailbox, or dispatched, was the event that turned the acceptance into a binding acceptance that took away from the person making the acceptance the ability to withdraw that acceptance. It's already become binding then, and the buyer, the offeror, no longer has the ability to withdraw their offer because the seller had dropped it in the mailbox. Okay, so looking at that situation and then moving forward a few decades, now you have transmission in a much more immediate sense, and that is the moment at which you hit send on the fax or send on the email, and in some cases I would submit that may even be when you text, whether it's attached or not. So the bottom line is that the concept, as Jeff has said, contract law never changed. All we're doing is trying to bring it into the 21st century and explain in the instruction section when the contract becomes binding. Because when it becomes binding, essentially you've had a meeting of the minds, and secondly, the offeror no longer has the ability to withdraw their offer. And I think I'm going to make one additional statement here before we get into the examples, and that is that there is a little bit of a difference between withdrawing an offer, such as when the buyer wants to withdraw the offer prior to acceptance, and when the revocation is made. So if the buyer wants to revoke, it is not as simple as transmitting a revocation. That is to say, let's say that the offer was made in writing, the seller has it now, the seller has signed it, and they haven't yet transmitted it. All right, so the buyer has then the ability to withdraw, revoke that offer. But the buyer has an obligation in order to make that revocation effective to give actual notice of that revocation. So I'm not going to get into whether or not it's got to be in writing. Let's just assume that a verbal is, at least initially, would be sufficient. So if the seller goes to bed that night, it's 10 o'clock, and they've signed it, but they haven't transmitted it, and the buyer calls the seller and says, I am withdrawing my offer. It's not been accepted, and it had to be accepted by 5 o'clock tomorrow, and I'm withdrawing it, and I am faxing or emailing to you or your agent the notice of withdrawal, right? That's good enough as long as it is actual notice, but it's got to be actual notice. In other words, if the buyer sent an email to the seller or the seller's agent attempting to withdraw, and it went into voicemail, and the seller didn't know it, that revocation or withdrawal is not effective. Okay, let's look at the examples now. Let's see. I'm going to go through these, and then Jeff and I are going to be batting the answers around a little bit. We're starting off with a pretty simple hypothetical on example number 1. On Monday, buyer signs an offer through the broker, submits it to the seller, giving the seller until 5 p.m. on Tuesday to accept, reject, or to counter. So the seller's got until the next day. Seller promptly signs the acceptance section of the sale agreement, gives it to his broker at 9 a.m. on Tuesday, and the broker faxes it back to the buyer's broker at 9:30. Okay? So the result, as I say, this is pretty simple contract law. The sale agreement became binding on both parties at 9:30 when the seller's broker transmitted the accepted offer via facsimile to the buyer's broker. I don't think that there should be any complication on that. And of course, the rule is that the moment the acceptance is transmitted is the moment that you have the meeting of the minds and the contract has become binding, and the buyer is no longer able to withdraw their offer. Now, every once in a while, you get into issues where what happens if the method of transmission is markedly different than the method of transmission that had occurred before. And I'm not going to spend a lot of time on that because essentially what you're getting into now is if the customary method of communication has been something other than email, for example, then can one party or the other use a different method of communication? And that's, now you're getting into some of these more esoteric, refined questions. Just as an aside, if you think that the law of offer and acceptance has continued to develop, you'd probably be wrong. That is to say, offer and acceptance, all of the law that could be made, I suspect, was made back when the mailbox rule existed. And I have researched the issue of whether or not an agreement can become binding via email, and there is not a whole lot of case law on that. Or to put it another way, almost by analogy, what you have to do is look at the old case law and then analogize it to, for example, the transmission rule under with the use of email or fax, because this contract law developed years and years and years before technology allowed us to do what we're doing today.
So there's a question that's come in then about actual notice. So if they've left voicemail, email, text, but they haven't spoken to the other party, is that not considered actual notification? I mean, if they've left the voicemail, they've submitted an email, they've sent a text, and I would say the email is probably the most quantifiable of those, right, where you can prove, I sent you an email, at this date at this time, and I've got a stamped email showing that it was sent to you. I guess that's the question is that considered actual notification, or do you actually physically need to connect verbally or get a response to that notification back from the other party?
Well, that's a $64 question. I mean, anybody that had, the level of understanding that we're talking about right now would say, well, gosh, clearly the seller could very well just make themselves incommunicado, not check their email, and not answer the phone and those sorts of things, not pick up the faxes, and then say, I don't have actual notice. So the question is really honing in on what I would regard as a factual issue, and that is whether or not the actual notice was effective by some level of proof that the seller actually knew about it. But I agree that a seller could play fast and loose and pretend like they don't have notice of a revocation. I think it would be probably, well, it requires a little bit of subterfuge to do that, because number one, if the seller wanted to accept, they presumably should have, and this is what you should do, is sign and then transmit as soon as it is your intent to transmit that acceptance. And Jeff, you and I talked about this before, about signing it but not transmitting it. Why don't we address that right now?
Yeah. So I think the bottom line is, if the seller accepts the offer, then transmission is critical, right? I mean, that's the point at which
yes,
you have acceptance. So getting it to the other party in as quickly of a fashion as you can, immediately if you can, is critical. And right now there's so many technological tools that will help you with that, whether it be incorporating somebody in via DocuSign, or we've all got emails on our phone. There's so many ways that we're available to our clients these days. I find it hard to believe that if you know you're in the middle of negotiating a transaction, that you're going to go silent for a long enough period of time that you're not going to be able to reasonably communicate one party or the other's acceptance in a timely fashion.
Well, but there was a situation that you and I were talking about where your seller wanted to sleep on it.
Right.
And why don't you explain that? And really, I think what I regard as a good practice.
Yeah. So I've had circumstances where a seller may have said, I'm not going to be available tomorrow to sign this agreement. I'm inclined to accept it, but so I'm going to sign it, but I don't want you to transmit anything until I call you in the morning before I head to the office and confirm that I am going to accept it. And so I'll sit on that overnight and wait for the client to call me in the morning and confirm that, in fact, they do want to accept the offer. And then once they say so, then I transmit the offer, transmit the acceptance.
Correct.
And I believe that's a perfectly legitimate way to do business, and okay for me to deal with if it were my seller in that circumstance in that fashion. They have a right to have me as their agent and say, logistically, I'm not physically going to be able to sign a document tomorrow. I am inclined to accept the offer, so I'm going to accept it tonight, but I do not want you to transmit it until I communicate to you that I want it transmitted. And I believe that's acceptable. I'm curious your opinion.
Sure. It is acceptable, because what you're describing is only one half of the acceptance protocol. You've got to sign, yes, but it's also got to be transmitted. So your client is saying, I'll do the first half, but I'm not going to authorize you to do the second half. And until that's transmitted, then you do not have an acceptance. And right. Yes, it's a perfectly legitimate way to approach the decision-making process. I suppose I would add to my seller, I would say, you understand that the buyer can revoke their offer at any time prior to the transmission. So if you want to sleep on it, fine. But if the buyer wants to withdraw and gives us notice of their withdrawal before you have decided you've authorized me to transmit, then that's going to be buyer's opportunity to withdraw is going to be effective because it occurred prior to transmission.
Right. Okay, good. So we have another question that's come in about what about a case where delivery is incomplete? For example, number of pages of the contract are missing from the transmittal, and what about cases in which brokers fax or email signature pages only? So, maybe you get a 9-page offer, right, or a 10 or 11-page offer, but all they send you is the last page showing that the seller accepted the offer. They don't send you the full 9 pages with the seller's initials on everything.
Yeah, I've seen that from time to time. I sometimes regard it as sloppy. Other times I regard it as the sender is trying to save a couple of bucks or the time of faxing 10 pages. They just want to fax the last page. And I've seen this, and I'm talking about among attorneys, where you get back a copy of the signature page, but nothing else. I'm going to assume that when somebody sends back a signed last page, it's fair for the other side to believe that nothing was changed on any of the other pages. I think I would prefer to see the entire document transmitted, but I don't look at that as the kiss of death to that transaction. Similarly, if there's a page or two missing, hopefully those pages that are missing were not intentionally missing with changes in them or something like that. I mean, the kind of questions that we're getting are, number one, legitimate questions, but those are the outliers. Those are the questions that are on either side of the bell curve of what is normal.
Right.
And you won't get a direct answer from me on those issues because they are so fact driven. For example, whether or not the seller is making themselves intentionally inaccessible in order to prevent the buyer from withdrawing. Which, by the way, let me just address that for a second, because the more you think about it, you think, well, wait a minute, why is the seller making themselves inaccessible? All they had to do was sign and transmit their acceptance. So if they haven't transmitted their acceptance, what are they doing with this game plan? I mean, why not just transmit the acceptance and be done with it? So I think that good practice dictates that when your client is ready to pull the trigger on the deal and say it's a go, that you as the broker have a responsibility to immediately transmit that signed document. Don't wait. Don't assume that tomorrow is as good as today, or it's 11 o'clock at night and it can wait. I would simply immediately get it out. You're doing a service to your client, a huge service to the client when you do that. And waiting, Murphy's Law says that if you wait, something bad will happen, and the buyer will withdraw the offer before you get around to making the transmission.
Yeah, and that can bring up a point of frustration for a lot of agents. You know, I mean, the 11 o'clock at night scenario is one that all too many of us, you know, deal with on a regular basis in our profession. And I would encourage you to, you know, take a look at some of the tools that are available for you in helping you address that, like DocuSign, where you can, you know, upon the seller's acceptance, have that document then immediately transmitted to the buyer's agent, so that they, as soon as the seller signs that they've accepted the offer, it can go, a copy can go right to the buyer's agent, thereby notifying them immediately, without you having to be, you know, watching your iPhone at 11 o'clock at night or waiting by your computer or your fax machine. And we had jokingly a question that came in that said, what is a fax machine? Because no one uses them anymore. But there's a lot of technological tools and things that you can do now to help alleviate that burden on you. There is another question, and it's timely, so I'm going to go ahead and ask it now. I know we want to get through these other examples, but this is one that I've dealt with a lot in my office and had from agents in my office, which is, if the seller signs an offer at Tuesday at 9 p.m., and then it does not get transmitted until the next Wednesday at 9 a.m., what is the first day for counting the timelines? Would it be the Wednesday or the Thursday? And then in parentheses, it stated mutual agreement was clearly on Tuesday at 9 p.m., but transmittal did not occur until Wednesday. And that's the notion. That's one of the reasons I think we changed the language in the sale agreement. Mutual agreement never actually, that language I don't think actually existed in the sale agreement. It's just been kind of a trade term that we've used, and that's why we intentionally called it signed and accepted, right? That's the language.
Yeah.
So can you help us with that timeline? When would you start counting the timeline in that circumstance where you have the written acceptance is at 9 p.m., but it clearly has not been transmitted to the receiving party until 9 a.m. the following day?
All right. Well, first of all, I'm going to admit that the term mutual acceptance, which is what appeared for so long, I used that term in the sale agreement in order to avoid having to put a fine point on what that was. Everybody seemed okay with it. Everybody seemed to understand it. But it was just sort of a shorthand way for me to say mutual acceptance is really when the contract becomes binding, without actually getting into the nitty-gritty about about signing and transmitting. So now that we have the term signed and accepted, and we have it as a defined term, meaning when it's been signed and transmitted, then the agreement becomes binding at that moment in time. And frankly, if I understand the question, I don't know any other way to count it, to count your time going forward than from the time that the document has been signed and accepted. So if it was signed and accepted, shall we say, on the weekend, then it's going to become, the first day that you're going to start counting would be the next business day, a Monday. And if it was signed and accepted today, then the first business day that you would start counting would be tomorrow. I would not look to the date that it's signed as the date from which you should be regarding it as the starting point. The starting point is from and after the date that has been signed and accepted. Have I answered that question?
Yeah, and to put a finer point on that, right, the acceptance being when it was transmitted back to the receiving party. So in the example that was given in the question, it's signed at 9 p.m. on a Tuesday. It's not transmitted until 9 a.m. on a Wednesday. That means the acceptance is at 9 a.m. on that Wednesday when it was transmitted, and therefore the time calculation would start in business days after it was accepted, which would be Thursday. Correct?
Correct. And to amplify on that, I'm afraid I hope this doesn't give anybody any heartburn, but we're talking about transmission. We're not talking about actual notice. So, for example, if a document an offer was signed by the seller and accepted, meaning transmitted tonight at 9 p.m. via email to the agent, that's the time at which the agreement became binding, even though the buyer doesn't know that it was transmitted at that time. Right. Or to put it another way, let's say that the buyer didn't know, and so the buyer calls up the next morning and tells the seller or the listing agent, I'm withdrawing my offer, and the buyer doesn't know that it's already been signed and accepted, i.e. transmitted. That's too late. Even though the buyer didn't know they were bound when the seller made that irretrievable act of transmitting their acceptance.
Yeah, good. One other quick question, and I'm just going to address it real quick, is would an acceptance start when the seller acknowledges the buyer's acceptance? And, the seller could acknowledge at any time. I think really critically, if you as the buyer's agent say, my buyer's accepted this offer, or you're the seller's agent, my seller's accepted this offer, I've transmitted that back to you at 9 a.m. on Wednesday, that's when you have acceptance. The seller or the receiving party may take a day or two before they physically are able to sign the acknowledgement of that on the actual document, but that doesn't start the clock.
No, in fact, that signed acknowledgement issue, which we're going to be talking about later, is found at sections 44 and 45 of section 44 of the sale agreement, and that the genesis of that provision originally a few years ago was required by the real estate agency that there be an acknowledgement by the buyer of the seller's acceptance, but that was not in order to make the contract binding, although it's been a sort of a urban myth that somehow the contract doesn't become binding until the buyer acknowledges the seller's acceptance, and that's not correct. The reason that was in there is so the real estate agency could walk into to an office, look at an original sale agreement, and see that it had made the complete circle. It had gone out as an offer, it had been signed as an acceptance, and the buyer got it back. And that's the only reason that's in there, is because the agency wants to see that the offer has circulated all the way around and everybody's on the same page. But the agreement became binding, not when the buyer acknowledged the seller's acceptance, but when the seller transmitted their signed acceptance.
Okay, let's move on to example 2 then.
Why don't you go ahead and read it?
Right, so on Monday you've got a buyer who signs an offer and through their broker submits it to the seller. giving the seller until 5 p.m. on Tuesday to accept, reject, or counter. The seller promptly signs the acceptance section of the sale agreement, gives it to his broker at 9 a.m. on Tuesday, but the broker forgets to immediately fax it back or transmit it back to the buyer's broker. At 10 a.m. on Tuesday, the buyer's broker calls the seller's broker to say that he just emailed him a written revocation of the buyer's offer. The seller's broker says, "You're too late. Seller signed accepting the offer yesterday."
Okay, so we've got a situation where the listing agent dropped the ball and didn't transmit the seller's acceptance back in time, it looks like. Correct?
Right.
All right. And so when the buyer attempts to revoke, the listing agent says you're too late because we already signed. What are your thoughts on that?
Well, yeah, I mean, I think the buyer has the right to revoke. They had no notification that the seller had accepted their offer, right?
No, they didn't need to have notification of acceptance. The point is that the acceptance hadn't been transmitted, isn't that right?
Right.
Okay.
Right. Yeah, so the acceptance of the offer had not been transmitted, so the buyer didn't know that the seller had accepted their offer, and that puts the buyer in a position where they have the right to withdraw or revoke.
Yes, because there was no transmission.
Right.
I mean, a similar, or maybe the other side of the coin would be the seller signs and transmits at 10 o'clock at night, but the buyer doesn't receive that transmission. Buyer attempts to revoke, and then the question is, can the buyer revoke? And the answer is no, the buyer can't, even though the buyer didn't know that the seller had transmitted the acceptance. So the buyer doesn't have to have actual notice of the acceptance. It's enough that the seller transmitted, making irretrievable their acceptance.
Right.
And so that's the other side. Is if the agent. That's why as a listing agent or even a buyer's agent dealing in counteroffers, that you want to transmit as soon as your client gives you the authorization, because immediately when you transmit, you take away the other party's ability to revoke that transaction.
Yeah. Yeah, so a good question about how does this apply when dealing with, banks and, properties that are in foreclosure. And I don't know that the application is any different. It's just the communication sometimes is a little more difficult, right? Because you're dealing with an entity who's got an asset manager that is only working 9 to 5, and sometimes the communication is not the best.
Well, you're being charitable. This is what's called the golden rule. He who has the gold makes the rules. So it's the bank in this case. They don't care what contract law is. I mean, they're going to do what they're going to do. And also, if you look closely at the term, here's my experience: is when the banks get an offer written up, say on the standard form, they will, at least they have been, giving an addendum that completely emasculates the offer. Completely, I mean, it may accept the offer in terms of the price and terms, but it completely changes the definition of when it becomes contractually binding. And in most cases, that addendum, which goes on for pages, will likely say that we can withdraw this at any time until it's been signed by the Pope. And they can set their own rules and change their mind, and good luck to the person that wants to try to sue the bank for specific performance. They will outspend you every time. So when you're dealing with the bank, you really have to take everything with a grain of salt and make sure that from an educational standpoint, your client understands that. We're going to do the best we can. I don't want to be negative, but I'm here to tell you that if the bank wants to change their mind, they pretty much can whenever they want. So we want to make sure that we do everything according to Hoyle and push this thing through as fast as we can.
And there is a notification for whoever asked that question. You probably know in the ORF library that there is a notice that you can give to your buyer, and should, if they're making an offer on a bank-owned property, that advises them of all of the potential perils and risks that we know of. And that form was created a few years ago specifically for this purpose.
Yes, good point. Okay, I think we're moving to example number 3. I'll go ahead and read it, and then Jeff, you can opine.
Okay.
On Monday, buyer signs an offer through the broker, submits it to the seller, giving the seller until 5 p.m. on Tuesday to accept, reject, or counter. So it's the same hypothetical. Seller promptly signs the acceptance section of the sale agreement, but after sleeping on it at 9 a.m. on Tuesday, scratches out his name and time of acceptance and changes it to a counter offer seeking a higher price. His broker faxes it back to the buyer's broker at 9:30 a.m. The buyer rejects the counter offer, saying, Mr. Seller, you accepted the lower price. I see your signature there and the time. I know you scratched it out, but you're bound by that. What's the outcome on that, Jeff?
So I would say, that the seller has the right to do anything they want to up until it's been transmitted to the buyer. So if the seller accepted the counteroffer initially, but it was never transmitted, and while they were, in midstream and thinking about it, they decided to change their mind and they scratched out their signature and then chose to counteroffer, I think that the seller has the right to do that.
Yes, they do. That's the tree that falls in the forest and no one's around to hear it. So the fact that the seller signed means nothing until it's transmitted. And once it's transmitted, it then becomes binding and not before.
And that's a fair point too to bring up as we're talking about, using DocuSign as an example. If you're going to include the buyer's agent in this example in that loop, right? So you communicate to the seller says, I'm going to accept this offer. You put it in DocuSign for the seller to accept, and immediately in chain after the seller's signing it, it goes to the buyer's agent so that it's been delivered to them. That'd be a point you'd want to make to your seller, right? That, listen, here's what's going to happen. The course of events is, as soon as you're done signing this electronically, the other agent is going to get a copy, which means it's been transmitted, and now that's it, right? You'd want to make sure that your client understood that and was clear that their signature in DocuSign on that, if that's how you have that loop set up, is it.
That's it. That's it. In fact, we're going to be talking about a similar concept in a little bit about whether or not you can withdraw an acceptance. Okay, let's see.
Moving on to example 4.
Yeah.
So this one we needed to reword a little bit. Do you want me to go through it, or
yeah? Why don't you go through it? I was the one that drafted it, and I made a mistake. So you correct it for us.
Okay. So the Monday, buyer number 1 signs an offer and through their broker submits it to the seller, giving the seller until 5 p.m. on Tuesday to accept, reject, or counter it. The language that was left out there, I think, is that the seller counters to the buyer, giving them until 5 p.m. on Tuesday to accept it. And in the meantime, buyer number 2 submits an offer, which the seller accepts and has his broker transmit the signed acceptance to buyer number 2, while the counteroffer to buyer number 1 is still out to buyer number 1 through their broker. Before 5 p.m. on Tuesday, buyer number 1 transmits their acceptance back to the seller.
Of the counteroffer.
Yeah. So the seller has submitted a counteroffer that they did not withdraw. They received another offer, accepted the other offer without withdrawing the counteroffer, and now the buyer accepted the counteroffer. So that's the example. That was the language that was left out. I'm being asked to read it again, so I will. So buyer number 1 signs an offer and submits it to the seller with an expiration of 5 p.m. on Tuesday. The seller counters that buyer number 1's offer, giving that buyer until 5 p.m. on Tuesday to respond to the counteroffer. In the meantime, prior to buyer number 1 accepting the counteroffer, buyer number 2 submits an offer, which the seller accepts, and the broker transmits the signed acceptance back to buyer number 2. And then, before 5 p.m. on Tuesday, buyer number 1 transmits their acceptance of the counteroffer back to the seller. So that's the chain of events.
All right. So let me restate where the problem. Let me state where the problem is. Then we've got the seller who has got a counteroffer floating out there. The acceptance or rejection they don't know anything about yet. And in the meantime, they get another offer that they accept, foolishly, I might add, because they don't know what buyer number one is going to do with that counter offer. And then Murphy's Law says that buyer number one is going to send in their acceptance of the counter offer. So now the seller has sold the property twice. So are there any takeaways, Jeff?
Well, I think, anytime you're in a situation like that, first of all, the seller should have withdrawn their counter offer to buyer number one before accepting anything with buyer number two.
Okay, now let's be real clear. Okay. So the seller knows they've got a counter offer floating around, and they can connect the dots and figure out that I better dispose of my counter offer before buyer number one accepts, because once they accept, then we got a contract. So I've got to dispose of that by a withdrawal or revocation of the counter offer, right?
Right. And I would say, in an effort to be overly protective of avoiding that circumstance, I might, even if the seller wants to accept all the terms of buyer number two's offer, I might recommend to the seller that we counter that offer saying, hey, we accept your offer, but it's contingent upon, our withdrawal of the counter offer that we have out to buyer number one, so that there isn't any risk there of, the seller having sold their home twice, right? That I'm very sensitive to that circumstance, and I think it's always best to overprotect the seller from having sold their home to more than one party.
Yeah, and there's another document though that's missing in the discussion. What's that?
A backup offer, right?
Backup offer.
Yeah.
Addendum. Go ahead.
Counter offering that, we want to accept your offer, but it's going to be in backup position until we have a resolution on the counter offer from buyer number one. But I think that the backup offer comes into play if the seller wants to have the possibility of buyer number one accepting their counter offer. But if the seller doesn't want that, if the seller's ideal is the offer from buyer number two is better, we don't want to put buyer number two in backup position. We want them to be in first position, but we're still going to make a counter offer. We're going to withdraw our counter offer to buyer number one, and we're still going to counter offer buyer number two, saying that our acceptance is contingent upon that withdrawal being received by the buyer prior to their acceptance.
Yeah. Okay. Now let's spend a minute on this. So if you are going to revoke, we've talked about this before, you got to give actual notice. And I think it's best to do it belts and suspenders, i.e. you call and you also fax or email the revocation. As long as you have confirmed that, in fact, the revocation has been received, I think you're in pretty good shape. I'll tell you what bothers me is if you put your offer, the acceptance of buyer number one's offer in a not a backup position, but sort of a conditional acceptance that we've got to dispose of buyer number one. Query whether or not you're making buyer number one a spoiler. If buyer number one finds out that they are still in the middle of this transaction, even though there's been an attempt to revoke. I have seen situations where people make such a nuisance out of themselves, buyer number one, that buyer number two goes away.
Right.
And I'm just making the observation. I don't have a particular solution to it. All I can say is that you want to proceed very methodically. For example, if you had the luxury of doing a revocation and effecting a revocation of buyer number one, the counteroffer to buyer number one, if you had the luxury of time, you would not only effect that revocation, but you would get a termination agreement signed. And as soon as you get the termination agreement signed, you've pretty much completed what you need to do with buyer number one, so that you can now deal with buyer number two, and you can accept buyer number two unconditionally in that situation.
Yeah, and it's an interesting nuance, right? Because you're talking about revocation as opposed to a withdrawal. So the revocation would come into play if buyer number 1 had already signed the counteroffer, but it just had not been transmitted back yet to the seller. So therefore it wasn't accepted because it hadn't been transmitted.
Correct.
But in the circumstance where buyer number 1 had not yet even signed the seller's counteroffer, then you're just withdrawing it. You're withdrawing the counteroffer because the buyer hasn't signed it yet.
I'm not sure I make that distinction.
Okay.
I'm not sure that I make the distinction that somehow the buyer number 1 has vested has a vested right by signing without transmitting. I don't think that signing without transmitting is any different than not signing at all.
Okay.
I mean, that's the way I look at it. In other words, the seller on their counter offer something more special, unwind the counter offer, than simply affect a notice of the revocation, whatever you want to call it. I think you're distinguishing. I'm using those terms interchangeably, and I think you're saying withdrawal means that you're withdrawing it before the seller is signed. Is that what you're looking at? Sort of?
Yeah.
Yeah.
I'm sorry. I was distracted by looking at it is, you know, the seller in this example could withdraw their counteroffer because it hadn't been signed by the other party yet.
But
So
even if it's been signed but not transmitted, it's the same thing.
Still could be withdrawn.
It's, yes, withdrawn, revoked, whatever the terminology is, you want to unwind it, yes.
Right. But in relation to the point of getting a termination agreement, if the seller withdrew the counteroffer prior to the buyer's accepting of it, there would be nothing to terminate, right?
You know, you're right. You're right on that. Yes, yes, yes. I apologize. Yes. You don't terminate an agreement that hasn't been consummated yet. That's right.
Right.
Is there a question there?
No, I think that we'll come a different question that we'll come back to. So there is one question about whether or not the agent has any liability there, and it's being said as the buyer's agent, but I think what it's meant as is the listing agent. So the listing agent in this example number 4, who represents the seller, received an offer, received the seller's counteroffer and transmitted it, received another offer from buyer number 2, and the seller signed it, and then that listing agent transmitted it back to buyer number 2. Nowhere in here does it say whether or not the listing agent recommended to the seller that they withdraw their counteroffer to buyer number 1. But I think it's fair to say that if you don't want to be the agent wrapped up in the middle of that deal, I'm guessing, right? I mean, that looks bad on you. If you're the agent and you've helped your seller sell their house twice, you haven't managed the transaction properly. Is that a fair statement?
Well, yes. In fact, what the agent's done is painted a great large bullseye on their back with attorneys for both sides aiming.
Yeah. Okay. All right. Example number 5.
Yeah. Go ahead.
So follow this one. Buyer signs an offer and submits it to the seller on a Monday, giving the seller until Tuesday to accept, reject, or counter. The seller timely responds, but with a counteroffer, giving buyer number 1 until 5 p.m. on Wednesday to accept, reject, or counter. The buyer timely responds, but with a counteroffer, giving the seller until 5 p.m. on Thursday to accept, reject, or counter.
So let me jump in. So the buyer now has countered the seller's counter, right?
Correct.
Okay.
So offer, seller counter, buyer counter.
Yep.
So the ball is in the seller's court, whether they want to accept, reject, or counter the buyer's counteroffer.
Correct.
And then immediately thereafter, the seller's broker informs the broker for the buyer that another backup offer has come in from a second buyer. Learning this, the buyer for buyer number 1 issues a revocation of his counteroffer and accepts the seller's earlier counteroffer. Now the difference between, and you and I discussed this before the call, but the difference in my mind is that the counteroffer had already been delivered to the seller. So the buyer's counteroffer had been delivered to the seller, and now the buyer wants to unwind that. The buyer undo counteroffer, seller's counteroffer that was submitted to them prior to. And I was, so I'll let you give it.
Well, this goes before what a counteroffer is. A counteroffer, automatic rejection, and it's a new offer. So there's two components of the counteroffer, a rejection and a new offer. So the question here is whether or not the buyer, in a counteroffer, can somehow say, that's the, if we said the buyer could do that, they could say, counteroffer, ignore my rejection of your counteroffer, Mr. Seller. What the buyer is able to do then is to force position of being able to accept another. In other words, the buyer is saying my didn't mean anything. I'm withdrawing that, and is they're taking away the ability of the offeror, the one that made the offer. In this case, it was a counteroffer. Their ability to actually entertain any other offers. Let's say a buyer makes an offer. This is just off the top of my head. So let me see. So the buyer makes an offer. Let's see, and it's open until offer, and it too is open until 5 p.m. today. So now the buyer has to decide whether or not they're going to accept or not the counter offer. Can the, by simply revoking their rejection, do that and force the buyer then into a position of having to accept the offer that was previously rejected? You can't do it. In other words, you can't say no to an offer and then say yes. So the only thing when you're doing a counter offer, the only thing you can change is you can withdraw the offer component, but you can't terminate, revoke, or withdraw.
Okay, well, I'm getting a lot of commentary that the audio was cutting in and out, unfortunately, during that whole section. So I hope we're not currently having that issue. It seems like it's getting better for most people. We're going to go ahead and repeat that. I'd like to run that example again and run that discussion again. I think we're back on. This is a recorded webinar, so you certainly, I believe, will have access to this webinar afterwards through the OREF website.
When our new website.
When the new website's up, we'll have access to this webinar, and you'll be able to hear the discussion. But we're going to do our best to redo that discussion. I know that was a long-winded discussion. Sorry, Phil.
Yeah. Okay. Let me go back.
All right. So I'm going to read through example 5. We're going to start over. I'm going to read through example 5 again, and then we'll just have our, re-illustrate the discussion. Thank you to all for your comments. Sorry the audio skipped out there for a minute. I don't. And makes the attempt to accept the seller's earlier counteroffer. and you had illustrated some issues with that, and I'll just let you give your explanation.
Okay, I'll try to simplify it if I can. Let's talk about what the issue is here. Is we've got a buyer that rejected the seller's counteroffer. So having learned that there is a backup, what the buyer is trying to do is to keep the seller from going to that backup, accepting the backup. So the buyer says, forget my counteroffer, forget my rejection of your offer, and the buyer is trying to snap up the seller's counteroffer that had originally been rejected. Now, what the buyer is trying to do is keep the backup offer from getting into a first position. Buyer can't do that. The buyer's rejection is, once transmitted, is automatic. They cannot snap it up again. They can't change their mind and go back and give it new life. The buyer can, in their counteroffer, they can certainly withdraw their counteroffer, but they can't withdraw their rejection. That's the whole point. That's why I said the counteroffer is two things. It's a rejection of an offer and it's a new offer. So that's I think restated a little bit more succinctly than what the discussion was before, but that's the point. Don't reject, don't make a counteroffer if you think that somehow you can withdraw your rejection, because you can't. And if you could, then that means effectively that the buyer in this case can prevent buyer number 2 from being elevated to a first position. And that just isn't the way you do it. Once you reject, there is the buyer number 2 is elevated to a first position.
I think that clears it up a lot. I'm glad we had the opportunity to go through that. I hope you can all hear us. Again, if we are cutting in and out, at some point, as soon as we can make it available in the future, the full recorded audio of this webinar will be available to you. So I think at this point, we're moving on to the final section, which is just a discussion and a conversation about some tips. And Phil, you've made a list of some tips here that I'm gonna let you talk about. The only thing that I really want to add to this is some fine point on some points that we've already made, which is do your best as the agent involved, if you're representing the seller, to overprotect your seller from the possibility of having accepted more than one offer. And it always comes down to communication for me and verification of that communication. You want to communicate, and you want to do it in a fashion that you can verify happened, right? That clearly is not open for discussion whether or not it actually occurred.
Correct.
And so I think if you do that, and I would always run the risk of if seller had made the example of seller making counteroffer out, then buyer number 2 submits an offer before. Even if the seller withdraws their counteroffer out to buyer number 1, I would still make a counteroffer to buyer number 2 saying it's contingent upon the successful withdrawal of their counteroffer to buyer number 1, just so that you don't have the possibility of the seller, or of having to explain yourself in a court or to an arbitration panel or in any dispute resolution mechanism. You don't want to be in that position. So the other thing that I would say, as I've already illustrated, is utilize DocuSign as a resource for helping you get delivery of those things, right? It's a great resource. It helps you from having to sit by your smartphone at 11 o'clock at night waiting for somebody to accept so you can forward it. If you're representing the seller and the seller says, I'm going to accept this offer, you can put the buyer's agent in loop behind the seller to receive a copy of that accepted offer immediately upon the seller signing it. And that's a good thing to do. You want to make sure, of course, in that circumstance that your seller knows that once they've signed it, it's immediately being transmitted upon their signature. So there is no opportunity for them to call you 20 minutes later and say, I've changed my mind. Mm-hmm. But as long as they know that that's what's going to happen, I think that's an incredibly valuable resource and a great way for you to use technology to help you not be so frustrated maybe in your business by having to sit by all hours of the night and day by your computer waiting for an acceptance to come in. So
Yeah.
those are the two big
Agreed.
points that I have, and I think you've got some other tips and tricks.
Well, yeah, but let me go back to I think something that you've explained in prior discussions that I think is incredibly important, and that is what I call a belts and suspenders approach, where you transmit the document. I think it's a prudent, good idea to also pick up the phone and tell the other broker what you've done, that we've accepted the offer and it's been transmitted back, something like that. That is even more important, not on acceptance, but on withdrawal or revocation, because it's got to be actual. So if you're going to withdraw, then I think you do want to email or fax out that withdrawal, and I prefer email head and shoulders above faxing, but which I think most people use, that or text. But I still see in my practice, I still see faxing, and I don't quite understand why. But in any event, so you do what you can with the actual notice, and you also then in the written notice, you also then pick up the phone and call the other side and let them know. So that way it's belts and suspenders, but you've certainly gone the extra mile to give that actual notice. Okay, so I think the first thing that I'm talking about here is that these rules that we've been talking about, I said the terms, they're subject to the terms of the party's contract, which, of course, if you're using the sale agreement, we know what those are because we just got through talking about them. The prior course of dealing in the transaction and customs and standards in the industry. And really, I'm speaking as an attorney here because it's not the standard transactions in the bell curve. It's the outliers that are going to cause the problems, and it's the problems that get resolved on some of these more esoteric issues of what had the parties been doing before, what was their course of dealing, what is the industry standard. So, and that's just sort of a big caveat to the black and white black letter law rules that we've been talking about. I said there's no effort to address situations in which the seller signs an offer and then calls the buyer to notify him of the acceptance, even though there hasn't been a dispatch yet. And then the question is, can the buyer revoke even though the seller gave verbal notification of acceptance? So the example would be listing agent calls the buyer's agent and said, we've accepted, but there hasn't actually been a transmission. They didn't push send yet. Yeah, that's I suppose a bit of an issue. You haven't got transmission, but you've got confirmation of acceptance before transmission. Again, that's the kind of situation that you want to try to avoid. So you transmit when you know the client has authorized you to do it, and then you give the verbal, not in reverse. I said no distinction's been made between a verbal revocation versus one in writing. Again, it's the same thing. If you're gonna revoke with the actual notice requirement, you want to send that email out immediately. What if it's just an email? It's not a written document. It's just an email, and then you pick up the phone and you say to the broker to whom you sent it, we're revoking. Okay, you haven't given the written document, but you've given an email document. These are issues that I think in today's world, the whole issue of writings becomes mildly irrelevant. It's good practice, and I'm not saying you shouldn't do it. I'm saying you want to use technology to the fullest extent. So I would prefer to have you do a termination agreement, have it signed, email it out immediately. But let's say that you want to move faster than that. Pick up the phone, say we're revoking, and send an email. We revoke, and then go ahead and send the email attachment with the revocation. You do everything you can to give notice to the other side, and in my opinion, that will go a long way on a court finding that actual notice was properly given. Yeah, you have a
Before you move on that point, then, so there's a question, and it kind of, I think, is right in line with what you're saying. So the question is, seller accepts the buyer's offer and gives the paperwork to the seller's broker. The broker calls the buyer's broker and says, the seller accepts, but delays in sending the actual signed document until after the deadline. Is that a good acceptance?
First of all, I think it's inexcusable. I hope I'm not offending anybody, but I mean, the acceptance is, the deadline is a deadline for acceptance. It's not a deadline to get around to it. It's a deadline, and if you don't have an acceptance, i.e., transmission of the signed document by the deadline, I think that you're creating a problem, and problem for yourself, by the way, from a licensing standpoint, because you had the ability to meet the deadline. You thought you were meeting it perhaps by the verbal conversation, but that just simply is not necessarily the case. And if the buyer was looking around or wanted to change their mind, you've given them a great excuse to disregard your acceptance.
So what about this example then, to draw that out a little further, to say, let's say I've submitted an acceptance to my seller in DocuSign. We've gotten an offer. My seller has said, yeah, I'm going to accept that offer, and I put it in DocuSign. The seller says, great, I'm going to be able to sign that this afternoon. I'm not sure the time. In the meantime, you know, the seller then does it at 3 o'clock. I'm in an appointment. I have access to my iPhone. I can see that at 3 o'clock the seller signed, and I got the completed agreement on my email. I can shoot a text, or I can forward that email. I guess I could shoot a text, or maybe I can call the other broker, but I don't have the ability to actually send the document at that exact moment because I'm busy. It's not because I'm being complacent, or I just happen to be, you know, predisposed otherwise, and maybe I don't have access to my email, or however the circumstance lays out. But let's say it's an example where it's a very tight timeline, and I would call the other agent and say, seller accepted, I've got it, but I can't get it to you until 6 o'clock tonight. The expiration was at 5 p.m., but the seller signed it prior to 5 p.m. I have it in my possession. I'm just not in a position where I can forward the actual document to you until later tonight. That's not a complacency circumstance. That's just sometimes what happens.
Okay,
right?
It's the real world. So here's, and I've seen that, by the way, situations like that. So if you contact the buyer's agent and say, I've got the acceptance here, I'm not in a position to transmit it until 6 o'clock, and I know 5 o'clock is a deadline. I would like you to ask the question, is that going to be okay? And having asked that question, then all of a sudden the buyer's agent's got to decide, you know, well, let me check with my client. I presume that's what they would say, or I hope that's what they'd say. So here's my point, is the acquiescence issue by saying nothing, and so you say, I'll get it to you by 6, okay? Okay, goodbye. And has there been a sort of a waiver of the time essence? I would submit there probably is, but I would say that if the buyer was looking for a way out, you've given them an opportunity. That's all I can say.
Yeah. Okay.
Okay, so I'm looking at what time do we have here?
We've got about 13 more minutes.
Good.
So
Okay,
there
good.
are a lot of questions that have come in. What I'd like to do at this point is, you know, let you get through the concluding remarks that you've got, and then we get to the questions in as much time as we have left.
All right.
Fair enough?
So yeah, I'm going to run through in about 3 minutes the balance of the material here. I think the main, I've got 2 or 3 points in writing, so you can read them yourselves. But one of the issues is, I said, make sure you always have the other broker's contact information, and I'm talking about from A to Z. If it's a home phone, cell phone, email, all of that. I think that's really important. I think that there's probably a good argument under the statute of fraud, or let me put it another way. I believe that the statute of frauds is becoming mildly irrelevant today. That is to say, I think a court would, with technology today, look upon an acceptance that was an email acceptance, but there wasn't a written document. I think they would look at that with more favor today than they would have 20 years ago. The statute of frauds was written in stone back in those days, but now communication and custom and usage is so much different today that I don't think that the statute of frauds is necessarily the be-all and end-all like it used to be. Under late-breaking news, we've covered this almost every time we talk, but this goes back to Section 44, and I talked about why that provision exists there, and that it had to do solely with the agency rules, wanting to see a completed circle on the transaction. And then we got into another agency-driven issue, and that is what happens if the seller accepts after the deadline and it goes back to the buyer, then what's going to happen? And the agency, this is a few years ago, said I think they slapped a broker because the seller accepted afterwards and the parties moved forward as if it was accepted transaction. And so what we tried to do is to clarify that once the acceptance of the seller occurred after the deadline, that acceptance is conditioned on the buyer's willingness to accept it as an acceptance. And so what we said is that if the buyer checks the box agreeing to be bound by the seller's late acceptance occurring after the offer deadline, this sale agreement shall become binding on the parties only when the buyers have signed below and transmitted it to the seller or the seller's licensee. Because effectively what's happened is that the late acceptance has really become a counteroffer. Okay, late acceptance has become a counteroffer from the seller, which means that the buyer has to accept that late acceptance or a counteroffer. And so we have the language in here that allows you to put the date, time, and method of transmission of the buyer's acceptance of the late offer. And that, and this text, in so many words, is found in both all of the sale agreements and also all offers and all counteroffers, seller counteroffers and buyer counteroffers. So let's go now to the questions.
Excellent. All right. So when there is an offer and a counter accepted by both, does the original purchase agreement need to be acknowledged by the buyer? So that's a little bit off topic for what we're talking about today, but still a question that's come up. And I would say, you know, your indication is that the acknowledgement section is more for the agency's benefit or for the agency's requirement of making sure that there's a written track proof that it's come full circle to all parties, right? So I would say yes, even if the buyer accepts the counteroffer, you would still want the buyer's acknowledgement on the sale agreement saying that the seller had countered them. Would you agree?
I'm not sure. I'd have to think about that because the way that it was contemplated originally was that the buyer was acknowledging the seller's acceptance. If you've got a series of offers and counteroffers flying back and forth, that effectively is an acknowledgement. Right. So as long as I'm not convinced that you need that buyer acknowledgement, you need to go back to that. If you have a seller that makes a counteroffer, that tells me that the seller has acknowledged, the seller has received it, and the seller has made a counteroffer, and then the buyer has either accepted that counteroffer. Well, you've completed the circle right there. Right. Or if the buyer makes a counteroffer, well, then you have to complete the circle one more time. But if you add up, if you connect the dots with the offers and counteroffers, I think you've got a completed transaction in the eyes of the agency. Yeah, and
I would say as a past managing broker reviewing paperwork, the easiest default for me is get everybody's signature on all of the places where they're supposed to have it. Right? So,
I agree.
Because then you're trying to figure out where the chain of event is, which was the last document, when did you need to get the acknowledgement that you didn't. But it's just so much easier to say, have the parties, whichever party it pertains to, sign the acknowledgement section on all the documents. Then it's clean and easy that way. And I think there are a lot of managing brokers that review paperwork that would probably agree with that. Maybe some that wouldn't, but I hear what you're saying.
Let me add that what Jeff is saying is better to be safe than sorry. I mean, it's real easy. It's not like signing the acknowledgement. The worst thing it's going to be is a useless act. But it's at least you've done it, and it could never be said that you've missed it. Nobody could rely upon that rely upon the absence of that and point to it as anything. So I think it probably, just from a standpoint of crossing T's and dotting I's, I have no difficulty with that. It's not going to kill the transaction.
Sure. Okay, so next question is, when you have a chance, please explain when a contract is binding with two sellers, Mr. and Mrs., and two buyers, Mr. and Mrs. Assume that Mr. and Mrs. Seller are out of town. What is the effect of one seller signing? Well, I'll let you answer that, Phil.
Well, I'm going to be a bit of a stickler on this. I mean, every once in a while, you do have a spouse signing for the other spouse. So husband signs for wife, or wife signs for husband. That's far better than having a blank signature line. I think there was some kind of a saying that used to be about, 2 to this and 1 to that or whatever. I don't remember, but I never could follow that. All I'm saying is that if an offer is being made, Mr. and Mrs. Smith should both be signing that offer, and it's being accepted. Mr. and Mrs. Jones should both accept. I've had cases where Mr. and Mrs. Jones were in the throes of a separation and going to get a divorce, and Mr. Jones, let's see, Mrs. Jones signed, Mr. Jones didn't, and they attempt to get out of the deal. So it made all sorts of arguments about, well, was one signing on behalf of both of them, even though the signature wasn't there, and even though they hate each other, and all of this other sort of thing. So don't allow yourself to give a client or the other side the ability to get out of a deal by leaving something unsigned. If they want to sign on behalf of the other, where Mr. Smith is signing on behalf of Mrs. Smith, let them go ahead and do it. At least you've got apparent authority, which is one step closer than a blank line.
Yeah, and I think the great leveler there is the change in the definition section of signed and accepted. So, the acceptance being the point of transmission. If I'm the listing agent and my seller signs the offer, and one party signs it and the other one doesn't, I'm not transmitting it until I have both parties' signature.
Exactly.
And the transmission is what creates the acceptance, not when when husband signed it or wife signed it. So, does that ring true?
That's a very, very good point. And in fact, when I go back and think of the arguments before, that was before we really had a clear definition of when acceptance occurred. And if one signs and the other doesn't, and it's not been transmitted with 2 signatures, then I don't think you have an accepted offer.
Yeah. All right, so good. Another question is, or a comment more, you should address that sometimes these emails and offer documents end up in a spam folder, so your transmission should say that the agent should inform you they received the message. I don't know that we're going to make a text change in the sale agreement, but I think you already illustrated the point about boots and suspenders, or whatever term you used. That
belts and
suspenders, right? You want to call. You want to make sure that communication has been made, right? And in the name of professionalism, we all want to do that, right? We want to be the kind of agent we would all want to do business with. So
yeah.
I would want to not only send an email, but call you and say, hey, we accepted the offer. I'm looking forward to closing this with you, or whatever it is.
That's exactly right. That is what professionalism is all about.
Yeah. Are texts legally accepted as well as email, and how are they expected to be stored in a transaction? I can tell you that I regularly will email myself a text stream between my seller, between my client and myself, for saving it somehow, or copy and paste it and print it into a document that I save electronically within the folder. So there's lots of ways. Technologically, there's probably an app for that. But there's lots of ways that you can save those text streams, and I would encourage you to do that. The question really for you, Phil, is a text legally as acceptable as an email? If you texted a listing agent and say, hey, the buyer accepted the seller's counteroffer, would that be of the same effect as if you emailed that acceptance?
Yeah, and I've had that question 2 or 3 times recently, and of course in our section 1 we talk about facsimile or email. We don't talk about texting. Although for all intents and purposes, texting, in my opinion, probably is the best, if for no other reason, because it's as immediate as email, but oftentimes it gets more attention than email these days, I think, and so
quicker response.
Quicker response. So whatever you're comfortable in doing, I'm okay with it. I look at them all electronic, whether it's email or text, pretty much the same.
Okay, very good. What about when a listing broker puts in the private remarks in MLS something like, offers received after 5 p.m. on a Friday will not be presented until Monday at 9 a.m. And I see that a lot in this market, where an agent will put in the private remarks, seller will not review offers until 5 p.m. on Friday, May 8th, for example. But you might submit your offer you know, whatever time during the week before that. You know, my take on that is that you as the listing agent, if you receive an offer, you have to deliver it to the seller for consideration as quickly as possible. But that doesn't mean the seller has to respond to it. The seller can respond to it whenever they want to. So I think it's fine to put in the MLS. The seller has already said, I'm not responding to any offers until, you know, 9 a.m. on Monday.
Well, not responding and transmitting the offers are two different things, and that's
Right.
what you're saying. Yes, I agree. You know, that if you look in the 696 800 series of the statute, you'll see the affirmative obligations, and one of them, of course, is to promptly submit all offers. So just because they're not going to be responded to doesn't mean that they're not going to be submitted. And if your seller doesn't want to spend the weekend looking them over, that's fine, but it's your responsibility to get all offers to the seller as promptly as possible.
Yeah. All right, we've got 1 more minute. I've got to get through a couple of these as quickly as I can. So what if the acceptance occurs before 5 p.m., but you close up shop at 5 p.m., so the documents are not transmitted until 8 a.m. the next morning? I think we've already answered that question, which ultimately is, you know, so long as you know and you've explained to your client that you don't have acceptance until you have transmission.
Yeah.
So, you know, as long as your client understands that if they're hiring you, that you have a cutoff, that you're not going to be available, and if something comes in after that time, then it's going to have to wait till the next business day or the next day. If they're okay with that and they still want to engage your services, I think that's okay.
Agreed.
Once an agreement is made and signed and acknowledges, what can a seller do later if they decide they no longer want to sell? Must they sell since they're bound by the contract? If they're willing to reimburse expenses incurred, could they have a lawsuit? I'm assuming that question really means could they have a way out?
The seller?
Yeah.
Well, I just wrote I wrote a piece on that. I think it's in the PMAR MBM Managing Broker. I know that it's also in the COAR newsletter, and it's called Seller's Remorse. That's part of the title anyway.
Yeah.
Seller's Remorse, and I can say that it's not a real level playing field. Sellers, when they change their mind, the buyer has got the remedy of specific performance, and they can cloud the title and do all sorts of horrible things during that time. So if the seller wants to change their mind, they're going to have to decide whether or not it's worth it. If the buyer wants to fight. You see, with low inventory, the buyer may not have another place to find it suitable for that same price and terms. So, yeah, sellers can change their mind, but the cost of doing so can become prohibitive. Whereas if the buyer changes their mind under the sale agreement, all they risk is their earnest money. And that's why I think listing agents should be very prudent about making sure that there is a significant amount of earnest money. Because if it's not significant, the buyer can walk, and the seller has no remedy except keeping the forfeited earnest money.
Great. Well, listen, we are out of time. As is always the case, the discussion leads to more questions than we have time to answer. So we thank you for participating in our webinar today. We're going to stay, and I will reply electronically to the questions that have yet to be answered. So if you have a question that you've written that has not yet been responded to, hang out for a few minutes after the call is complete. We'll get you a response in writing before we shut everything down. Thank you so much for participating with us today. We hope you learned a lot and enjoyed the time.